Congress has the power to do this. That, again, is significant because patents, what a patent is the federal government saying you have exclusive authority to, for some period of time, produce this invention. No one else can do that. Only you can do that. You, as the inventor of this thing, have an exclusive right to this thing. You have a monopoly over this thing. You can largely, with some exceptions that we'll talk about in a minute, you can largely do with that what you will, right? So you can produce it, you can sell other people the right to produce it, you can do all kinds of stuff, but it is fundamentally up to you. The first, there were other kind of prior statutes, there was some stuff in the 19th century, whatever, that really matters for purposes right now. The first law that we are really concerned with here, because it is still, it's been amended a few times since then, but it's still the primary statute governing patents, is the Patent Act of 1952. What this did was codify a set of key patent doctrines, many of which the court had, like we kind of got at earlier with the common law idea, had started sort of like cooking up and applying because they were faced with this task of like, okay, well, Congress is, like, Constitution says Congress can give people the ability to patent stuff. Congress has said, yes, people can patent stuff. We have all of these different concerns and issues coming up about like what sorts of things should be able to be patentable. And different courts throughout the country were coming to different answers to some of these questions. And so then Congress kind of stepped in, was like, this set of legal doctrines that have bubbled up with some adjustments, we're going to make them the law of the land. Here's how patent issues are going to be kind of resolved now. We're going to talk here in a minute about what those key requirements are. That is very important to understand and bears directly on, for example, the AI Patents Act. This second piece bears on the Pharma Act. We'll talk about that as well. So yeah, put a pin in this, we'll come back to it. Patent Act of 1952. Start that. Next thing, the Bayh-Dole Act, 1980, established the way that this works vis-a-vis federally funded research institutions. Again, we'll kind of talk in more detail here in a minute about what that means. But the pharma affirmative will have margin provisions is about this. The third law that we're going to kind of talk about a little bit, although we'll focus on this piece less right now, but it's likely to become relevant later in the camp, is the America Invents Act, which was passed in 2011, which shifted the U.S. to being a first-to-file system, meaning the way it works in the U.S. now is the first person who is who meets the lawful requirements of being an inventor for a thing that is patentable. The first person who is like, I'm filing this patent, is the person who has that patent. That might sound obvious, it isn't. There are all kinds of other ways that you can approach it. For example, this person filed first, but this other person actually played a larger role in initial conception of the thing. We're a first-to-file system. We'll unpack that more in a little bit. The way that patents work is the U.S. patent system is administered by USPTO. Like I said earlier, that stands for Patent and Trademark Office. The steps involved is when you go to file for a patent, there are kind of two main stages to this. The first is filing, which is where you submit your application for the patent. The reason that I wanted to take the time to kind of flag this or talk about it is because connecting back to this core, if you take away only one thing from this lecture, it should be that, again, the purpose of all of this is to balance incentives in order to maximize cycle innovation. The one major way in which the US patent system does that is this filing stage. Because when you file for a patent, you aren't just like, hey, here's this thing I want a patent on, and then it like goes to the government and like goes on a shelf somewhere or it's like a secret or whatever. Instead, you file for a patent, and as part of that process, you have to provide a ton of detail about what the idea is, how you produced it, etc. The idea being that while we do want to ensure that folks are able to have kind of exclusive, have a period of exclusivity so they can profit from the fruits of their inventive labor, we also want to ensure that once that period is over, everyone else can easily reproduce it. Why might that be a thing that, if what we care about is like maximizing societal welfare, why is the kind of disclosure component of this filing process so important? So I have thoughts. Yeah.
So like society can benefit on like, or like you can, I guess like everybody can have like access to it, I guess. Like,
Well, so yes, it is fundamentally about access, but so presumably that person, well, I guess in theory, it's possible that somebody files, isn't trying to proper thing and just sits on it. So one purpose of this is we want to ensure that can't happen. But let's assume that somebody is producing the thing and selling it or whatever. In what sense is this better for access once that ends? Like what effects does this have?
The laws of free market competition dictates that like once everyone can make it, the price goes down.
Exactly. The idea here is we want to ensure that once that period of exclusivity is over, that we harness the other major upside of the free market, the major upside of the free market system by allowing competition to rapidly drive down the prices. Because to your point, that maximizes accessibility, which is like you can think about this in terms of societal diffusion of given technology, right? Let's say you come up with some awesome new manufacturing process or some sweet new technology that like could change the world. And you're like, well, this is still a game changer, so I can make a ton of money from it. We allow people to do that temporarily, to have sort of a short-term monopoly on that thing. But we then want to, because again, based on the idea that knowing that you will get that, you will come up with those ideas and produce them in the first place. But we then want to ensure that that set of technologies or processes or whatever diffuses societally and has the cost-driven way down. Monopolies, very, very bad for prices. Monopolies tend to lock in artificially high prices because if I'm the only person who's able to produce this thing, I know that I can charge you whatever I want for it. And so that's sort of the balance that we try to strike. Does that make sense? Yeah.
What's the time period that a patent monopoly stands for?
Great question. So there are some potential exceptions to this, but for the most part, there are two main time periods. One is for, okay, so there are three types of, I don't think I can't think of any reason right now you need to super right into the details on these different things, but it is worth noting they exist. There are three types of patents that you can apply for that are governed by slightly different rules. There are utility patents, there are design patents, and there are plant patents. Right, so if any of you are familiar with like all the controversy and hubbub about like Monsanto patenting, a particular strain of corn or whatever that they genetically engineered, that's plant patent. The design patent is like, here's this, new process for this thing. Utility patent, I have this like sweet new machine or manufacturing method or whatever. Does that make sense? Okay. Typically for utility and plant patents, the patent period is 20 years. And typically for design patents, the patent period is 15 years. Yeah.
15 or 50?
15, 1 month. Other questions?
Sorry, did you say utility was a process or product?
Utility product and I think certain processes. I would need to look back at the definition, but primarily product. Other questions? Okay. So first major structuring premise here, time limited monopoly. Second major structuring premise, you then have to disclose all the details of this thing so that people can replicate it once that time period is over. That's stage one, is the filing part. Stage two is the Patent and Trademark Office employs a bunch of patent examiners whose whole job is to be intimately familiar with what things have been patented and all the rules and regulations around patenting, both in terms of the statutory law around it and all the different court decisions about what the different requirements are and how to apply them. Once you have filed, you then are examined by a patent examiner who will kind of go through the application you filed in detail, and there where they kind of like poke and prod at the idea that this thing is patentable and you've met all the requirements and stuff, and then if you successfully kind of make it through that adversarial process, you're granted a patent. Does that make sense? Here you can see that principle in play that we talked about from the US legal system earlier. If you could imagine a version of this where we don't have this stage, and it's just like you file for a patent, the executive branch gives you a patent, and then when you need to challenge, and then if you're somebody who is like a potential competitor of the person who filed that patent, or who came up with a similar idea, then in order to challenge the validity of that patent, you immediately need to go to the courts. That would be a disaster because the courts have to be experts in all kinds of areas of law. They are not nearly as kind of narrowly focused on patent law. It would also entirely overload them, sort of like judicial caseload wise. You could imagine the massive flood of litigation that would result from that. And so therefore having this kind of upfront ex-ante, really rigorous and sensitive check, very valuable. And again, if you do need to challenge a patent, often your first stop will be kind of go to the PTO. In particular, a board that if we have time we'll talk more about, we probably won't, in which case this will come up later in camp in the context of other apps. PTAB, PTAB, is the body that primarily reviews challenges to these patents when somebody brings one to the territory. Just so if you come across that, like, don't worry about that too much right now. If we have some time at the end of the Q&A, whatever, we can talk about it, but if you come across that acronym, that's what that means. Also, another thing I'm going to not explain right now, but I'm going to tell you is about this, so that you at least have like somewhere to slot it, is inter partes review. INTERPARTES. One of the apps that we will talk about later when we talk about things that are topical on, or things that are plausibly topical, depending on what interpretation resolution you adopt. Because it's one of the kind of current hot button issues in patent law is making tweaks to the way that PTAB does their job of reviewing these patents. So, quite a bit of that. Okay. Questions about any of this before we dig into the requirements that the patent statutes and subsequent court cases establish for what sorts of things are patentable and when? Yeah.
Trade secrets, where do they like fit into like the whole like system right there?
Great question. The answer is sort of in this category of potential alternatives. So hold on to that right now. If we don't end up, for time reasons, addressing it, like in passing over the course of this, then definitely bring that up in Q&A because we should for sure talk about that. Yeah.
So I know that when you give them disclosure on your invention, they will store that somewhere. When your patent expires, how do they spread that information?
Sorry, how does who spread?
The government, sorry.
Oh, so when you file for a patent, that's public, that's accessible. So like you can go now and see what patents people filed. It's not that it's like locked away until the end of that period.
Understood.
Yeah, good question. But which is the thing that we again can only do because of the fact that we do have this set of pretty strong protections on your ability to do stuff with that information, right? It's like, yeah, you can see it, but you can't then use it because otherwise you'll be sued for patent infringement.
So some